To be asked to give the Hamlin Lectures is a profound honour. I'm incredibly grateful to welcome Baroness Hale and thank her for travelling all this way to chair tonight's lecture. Baroness Hale is not just one of the country's most famous, most historic judges. She also holds a special place in the hearts of many legal academics and socio-legal academics, those who do empirical legal research in particular, including me. And I would like to give my deepest thanks to my colleagues for hosting the lectures and the trustees for asking me. I'm immensely proud to have been asked. But I know that the reasons for being asked are not about me or my work or even the great work of our team, Sally Day, Karen Noakes, Rebecca Helm and Paul Gilbert. It's about the story. It's about the problem, the people affected by it. Because I'm asked to speak about lawyers' ethics at a critical juncture, a moment of calamity for the legal profession and the legal system. The theme of these lectures is frail professionalism, the frailty and susceptibility of lawyers individually and collectively to bad decisions. Now, incompetence is part of this, but mainly I mean susceptibility to misconduct and the undermining of justice. So to the lawyers who have come, an especially warm welcome. You may feel sometimes a bit under the microscope. You may feel defensive. We all feel the adrenaline of an accusation when it's levelled against us, the fight or flight response. And I want to acknowledge that and recognise how hard it is to listen to criticism of our own kind. But the main reason I think we need to listen is the post office scandal. It is emblematic of how ethical and system failure can lead to profound injustice. And I think it speaks to a significant problem of honesty and responsibility in political, commercial and legal life. The problem is encapsulated in broader concerns about a cover-up culture, but also a sense amongst so many of the scandal's victims that there is one law for them and another for the powerful, two-tier legality driven by what I'm going to define as aggressive lawyering. I will argue that the post office, but also other cases, are emblematic of three things. The first is the subject of tonight's lecture, how unreliable gods, complacent, unaccountable lawyers with fearless logics are vulnerable to wrongdoing, how their logics spring from conventional but unbalanced ideas about professional partisanship, how those logics are structured by money, secrecy and moral sophistry, how they are amplified by human frailties, the psychological dispositions that magnify the chances of failure. The second lecture looks at how immoral, unreliable lawyering combines with unbalanced organisations, how irresponsible legal orthodoxies can drive cover-ups, deliberate concealment, a lack of candour, the retelling of half-truths, and the massaging of risk. And the third will suggest reform. Legal ethics is not solely a problem of individual lawyers or unbalanced organisations or legal and regulatory failure. Ethics is both an individual and a whole system problem. It requires change in corporate governance, court practice, legal education, professional leadership, and better regulation. But tonight, I start with this claim. The way lawyers think and behave has to change. Why? My first point is that legal aggression harms the rule of law. Stephen Vaughan, Kenta Suda and I have already shown how aggressive lawyering and the rule of law can conflict. There can be a hefty tension between legality and professional aggression. And I would define legal aggression as choices that are arguably legal, but probably unlawful or misleading. That aggression is driven by the rules, systems and culture of the profession and its clients. It's why we have slaps and questions about enabling oligarchs. It's why Parliament's Intelligence and Security Committee suggested that professional enabling threatens national security. It's why we've had Harvey Weinstein, Mohammed Al-Fayed, Philip Green, powerful men, helped by their lawyers deploying freedom of contract to draft menace and silence into the lives of their victims through non-disclosure agreements and non-disparagement clauses. Lawyers have helped banks with off-balance sheet accounting, with systemic risk-taking. They've helped by disguising commissions on share deals or designing lax money laundering controls that have even helped Hamas. In each of these cases, the choices made can be presented as arguably legal, but also often are likely to be improper or even criminal. Secrecy and rule of law rhetoric often shrouds them from scrutiny. It is the degrading of legal integrity and honesty that arises from this that concerns me most when I talk of ethics problems. That is the focus of these lectures. My second point is the post office scandal is sufficient reason to act. The post office is not one case, but hundreds, arguably thousands. The post office certainly ruined thousands of lives. People thrown out of their businesses and homes, sued and bankrupted, prosecuted and imprisoned. The cost has been extraordinary in scale and in scope. Minds and bodies are scarred. People have ended their lives. Many victims live on, of course, but in pieces. The scandal spans decades. The inquiry has exposed a litany of legal failure. Lawyers drafted contracts that were unfair. They offered a choice between sub-postmasters accepting debts they did not owe, or that drove them towards steps capable of amounting to false accounting. That choice was backed up by unfair termination clauses and the like. Lawyers also helped pursue debts with improper aggression. Lee Castleton, a sub-postmaster from Bridlington, was made an example of, ruined deliberately or simply as the natural consequence of litigation, depending on whose evidence you accept. In that case, a nice little legal point was developed based on an illusory simplicity and arguably inadequate disclosure. The claim was that sub-postmasters had agreed money was owed when signing off accounts. It was good law, but factual nonsense, requiring sub-postmasters to prove the Horizon accounting system did not work if they wanted to defend themselves. Prosecutions went ahead without key evidence for theft. False accounting was treated almost as a strict liability offence. Dishonesty was assumed rather than evidenced. Plea bargaining was conducted inappropriately. Plea deals silenced questions about computer errors and were designed to maximise commercial recovery for the post office. The prosecutions depended on expert evidence. That evidence was not independent. Experts were unprofessionally handled by the lawyers, improperly encouraged to change statements to help the post office's case. That evidence was tainted. Under political pressure, the post office agreed to review its criminal cases, and here began the period of containment. Disclosure was the main focus of that review. At the very point at which proper disclosure of evidence became the focus, disclosure problems deepened. The review of post office prosecutions had a conflict of interest. At its heart, the lawyers were marking their own homework. It was spotted by some lawyers, misdescribed, diminished, or ignored by others. Adverse evidence, some of it of smoking gun quality, was not disclosed by post office lawyers in civil or criminal cases. Indefensible, spurious, and sometimes merely unreasonable grounds were given for so doing. Lawyers wrote internal notes about how they were suppressing evidence. Inappropriate redaction of documents and exploitation of legal professional privilege took place. An investigation by forensic accountants, Second Sight, had its independence threatened by aggressive lawyering. Reports from lawyers to the Post Office Board were partial, they were incomplete and biased, and facilitated the misleading reporting to government and perhaps to Parliament. A complaints mediation scheme was run with hallmarks of obstruction and attrition. The group litigation was conducted on a scorched earth and what the judge described as a flat earth basis. It was littered with misleading arguments and evidence. A tainted expert helped in the shadows. There is a live question as to whether the High Court was deliberately misled about this. The Post Office tried to have the judge removed when it became clear they were losing the case. They enlisted two of the biggest hitters in law. Both advised the Post Office it had good prospects of winning. One of them told them they had a duty to remove the judge. At the inquiry, he said he did not mean legal duty. We don't know what kind of duty he did mean then. In court, he lost badly. At the subsequent criminal appeals at the end of 2020, the taint on expert evidence emerged for the first time. Neither barrister, who should have advised disclosure of core information about this back in 2013, had done so. One represented the Post Office before the Court of Appeal in 2020. The Hamilton appeal also revealed the alleged shredding of disclosure documents. The lawyers who'd been tipped off that they would be blamed for that shredding advised the Post Office it was potentially criminal. But for some reason they were then persuaded to call it a cultural issue that had been addressed. Undisclosed for 7 years, there is no evidence that this potential crime was properly investigated. Concerns continue to be raised on other matters to this day. Each of these points raises questions about the lawyers involved, lawyers senior and junior, in-house and in private or independent practice, King's Counsel and General Counsel. Not all of these questions are about potential professional misconduct, but many are, and that the inquiry needed to give self-incrimination warnings to several lawyers also tells us that some of them may be criminal. As such, as a tale of legal carnage, in breadth and in consequence, it is unparalleled. Even if no lawyers had done anything wrong, multiple legal car crashes over so many years with so many different hands on the wheel should demand change. Equally, and this is really important, no part of it is surprising. Each strategic step, each tactic, each mistake, each duck and weave is familiar. The story of the Post Office is a tale of awfulness, but also of orthodoxies. It is a story that has at its heart dangerous ways of thinking, poisonous logics and vulnerable institutions, as well as flawed and sometimes cynical individuals. But the idea of orthodoxy suggests something subtler than just bad apples being the sole or main cause. It suggests how something close to ordinary lawyering can render lawyers insensitive to ethical risk, and how certain orthodoxies, how particular cultural practices may drive failure. That suggests a problem that is bigger than the Post Office. Now, what do I think is driving ethical failure? How can lawyers lead themselves astray? Well, my first reason is why I spoke of frail gods. Frail gods is my clumsy language for highlighting what psychologists call the professional self-concept, a belief that, as a professional, I am ethically better. It feels like an unfair criticism. As professionals, we are supposed to be better, but there is a problem with an elevated self-concept. Miriam Kuchaki has shown how thinking of oneself as a professional increases a propensity to lie and cheat. In one experiment, students thinking of themselves as professionals lied and cheated for money 41% of the time. Those who did not think of themselves as professional did so only 6% of the time, and the professionals' lies were also much bigger. Professor Kuchaki's explanation is that we give ourselves a moral license to flex because we think of ourselves as better. Because I think of myself as a professional, I cut myself some slack. Sunita Saar shows that what matters is whether a high self-concept coexists with a shallow understanding and practice of professionalism and a belief that one's ability to self-regulate is sufficient. Her work shows how managers who consider themselves more professional were in fact more prone to conflicts of interest. There's a similar stream of work around objectivity bias. Those believing themselves to be more objective are often the least objective. Might an elevated professional concept be a problem for lawyers? The post office scandal has several examples, including lawyers saying they acted entirely properly and then being shown that they almost certainly had not. But I want to focus on a less clear-cut example to show how professional complacency can blend with another problem, that of moral distancing. Patrick O'Brien and Ben Yong, two academics, show that most retired judges think that they do not need to be regulated post-retirement. Although most retired judges did not engage directly in litigation, they were confident they would know right from wrong when deciding what they could do, but also they took different views on what judges were permitted to properly do post-retirement. Signs, perhaps, of a strong self-concept and weak scaffolding. Lord Neuberger, a former president of the Supreme Court, was asked to engage with the Bates litigation to advise at short notice on a recusal application. That application involved saying Mr. Justice Fraser should remove himself from the case for actual or apparent bias. As post-retirement advisory gigs go, this was at the more controversial end of the spectrum. The application flowed from the first major trial of this group litigation. It had been conducted by colleagues in Lord Neuberger's chambers, and the draft judgment for that trial showed they had lost badly. Lord Neuberger advised that the recusal application had reasonable prospects of success and should be brought. Another colleague from Chambers, Lord Grabbanner, handled it. The application, unsurprisingly, was declined by Mr. Justice Fraser and then criticised in damning terms by Lord Justice Coulson when appeal was sought. Now, Lord Neuberger explained his role in written evidence to the Post Office inquiry. He says he feels uneasy when I think, read or talk about the Horizon scandal. He also says that the topics on which I advised Post Office were not connected, at least in any direct way, with the appalling history of mistreatment of so many postmasters and postmistresses. I wonder about that. The draft judgment that prompted the recusal discussed malicious prosecution. Had the recusal prevailed, the Bates case would probably have been lost. The Hamilton appeals, which were based significantly on the Bates case, may never have been brought. The scandal might have been contained forever. He continued, although as matters turned out, my advice did not accord with the view taken by the courts. I was called on to advise in accordance with my opinions at the time, and that is what I did. So is Lord Neuberger distancing himself here, describing his own role in the narrowest of terms, cutting himself some slack? Well, here's an alternative take. There used to be a judicial convention against retired judges advising, particularly on live cases before the courts. Now, Lord Neuberger, not unreasonably, if debatably, thinks that convention has been abandoned. Lord Neuberger might have been aware of the concern, though, that judges advised in such cases, although he tells me many former senior judges have in fact advised on live cases before the courts. Now, this, of course, was a bit more controversial, a case about a judge, but more importantly, it is difficult to avoid the appearance, and I do not suggest this was his intention, the appearance that this aided members of his own chambers in a situation of great haste and with limited and partial instructions. What do I mean by that last point? His observations, he tells me, were to a substantial extent based on a note from his colleagues on reasons to recuse Mr. Justice Fraser. Lord Grabbanner conceded at the inquiry that this was an advocate's document. It was partisan, although Lord Neuberger tells me he did not think then or subsequently it was inaccurate or unfair. Now, a solicitor's firm could not claim to independently advise here. I don't think so. There is a strong potential conflict of interest also. Barristers, however, treat each other on the basis that they are completely independent of each other. And to be fair, they are used to opposing each other, even if the same chambers. So Lord Neuberger's approach is consistent with the bar's normal approach. But I think that normal approach is problematic. Team loyalty bias is subtle and subconscious. However independent-minded I am, I would struggle to comment totally independently on a colleague. Put at its gentlest, someone from another chambers would have been more independent. And if we turn to Lord Newburger's particular status, one does not have to think, as Lord Justice Pill did, that the track record of being a judge is commercially saleable and so should not be on the market to see risks here. Lord Newburger's name no doubt influenced the board, and through no fault of his own, Lord Grabbanner deployed his status by referring to an anonymous, very senior barrister or judicial person to try and help win the fateful recusal application. His status was leveraged. I should make clear, lest anyone thinks I'm nodding or winking, that I am not suggesting anything professionally improper by Lord Newburger, still less anything sinister or criminal. But the story suggests the kinds of problems that an elevated self-concept might lead to. Instead, his evidence to the inquiry paints rather technocratically in language of role morality, the bland language of mere advice. That he does so is not surprising, not just because he wants to avoid unseemly criticism, but also because his representation of the role fits with the dominant ideology of lawyers, narrow, immoral, and notionally independent. This leads to my second underlying problem: the dangerous logics of zeal. Role morality is the idea that the morality of my acts are determined by my role. Surgeons can cut, soldiers can kill, and so on. The kind of role morality most often associated with lawyers is that of zeal, and moral philosophers call it the standard conception as a result. Now, the standard conception provides a series of 3 reasons for doing what the client wants. The first is zealous partisanship. You must maximize your client's interests. The second is neutrality. Your own morality shouldn't get in the way. You should not prevent you from doing what they want you to. And non-accountability is the third. You are not responsible for what your client wants you to do. The idea is that the system gives the clients rights, and partisanship requires lawyers to maximize exploitation of those rights, and the professional role serves the system by serving their clients, the role morality. There are moderate and strong versions of this standard conception, but for our purposes, lawyers heading towards failure persuade themselves that they must do anything that advances the client's interests unless it is clearly prohibited by law or rules of professional conduct. They must do anything unless it is clearly prohibited. Now, the rules do not generally speak in these terms and contain restraints, so client interests do not come first. And, for example, a lawyer cannot assist in criminal conduct. A lawyer should not bring claims abusively, although abuse is narrowly defined, and a lawyer cannot mislead anyone. Moreover, a solicitor must not take unfair advantage by virtue of their position. Now, I would say, so keen are the philosophers and some practitioners to justify zeal, they can sometimes rush past or diminish these legitimate restraints, perhaps convincing themselves that only if clearly restrained do they need to be restrained. As a result, zeal does not encourage a balanced description of lawyers' actual ethical obligations under the rules and laws. So, to give you one example, integrity requires lawyers to take particular care not to mislead. Now, as I will show you in a minute, zeal can push lawyers in the opposite direction. And I'm going to show you by talking you through the story of Alistair Brett. Alistair Brett was an experienced solicitor working in-house for the Times newspaper. He helped a Times journalist, Patrick Foster, try to run a story on Detective Constable Richard Horton. D.C. Horton wrote an acclaimed blog about the police service under a pseudonym Nightjack. He was not leaking details of cases, but he was shining a light on how the service was run. Some at the Times thought Nightjack deserved to be exposed for breaching confidentiality and embarrassing his employers. The journalist, Foster, got his story by hacking Horton's email account, which was a criminal offence. His editor brought him to Mr. Brett for advice. Alistair Brett tried to help Foster get his story out, but did so in a way that led to him recklessly misleading the court. Now, the first thing to understand about how this happened is this. Brett felt able to regard Foster's confession of hacking as confidential and privileged. That meant he could keep it secret. Secrecy allowed them to create a different story and so help Foster try and get his scoop. What Brett does is he tells Foster off for his conduct and then says, but if you can identify him legitimately from public sources, we can run the story if you then front him up, that is, give Horton an opportunity to confirm or deny his nightjack. Mr. Brett was cross-examined on all this during the Leveson inquiry. Lord Justice Leveson suggested that the legitimate identification strategy was in fact a phony process. The map to the maze is, he said, already laid out. The point being, how can you claim to have identified Horton legitimately if you already know who he is? The legitimacy is an illusion. It's the start of a slippery slope. The strategy runs into difficulty when Foster fronts up Horton. Rather than cave in, as Brett expected, Horton goes to solicitor's firm Allswang's and seeks an injunction to prevent him being exposed. The Times have to fight or fold. They choose to fight. Allswang's asks Patrick Foster to swear an affidavit saying he did not hack DC Horton's account. They say this because he has a history of hacking email accounts, which he did. He was punished for it at university. Brett advises Foster not to respond, but by return he says this instead. As regards the suggestion that Mr. Foster might have accessed your client's email address because he has a history of making unauthorized access into email accounts, I regard this as a baseless allegation with the sole purpose of prejudicing Times newspaper's defense of this action. Baseless. Brett found sufficient excuse in his own mind, if he thought about it clearly at all, to say this. It's an example, perhaps, of a zealous argument. He doesn't have a history. Well, Foster had only done it twice before. Baseless. Well, Allswang's might not have evidence for the claim. Clever? Arguable? Balderdash? What was worse to come? When the case is presented to the court, Foster is asked to explain how he identified Horton. Brett's most fatal failure edges into view. Foster's statement, which Mr. Brett helped draft, explains how the legitimate searches were conducted. Not only were they conducted legitimately, they were said to have begun that way. He ignored, in other words, the privileged information of hacking, but also asserted something that was not true. Foster had not begun that way. Leveson starts to wonder in his cross-examination about Brett being too close to the situation and challenges him on it. Here we see Brett, in the thickets of his own subjective strategy, mired in his legal reasoning, passing the truth into the one bit of the story he wants to tell.
All I can do is, rightly or wrongly, I have believed that you could separate the earlier misconduct by Mr. Patrick Foster, and you could then say once he had done this legitimately, that could be presented to the court perfectly properly as he had done it legally. Now, I accept that you say that the two are inextricably intertwined, but that, if I may say so, is a subjective judgment. I mean, I happen to take the view that you could separate out the one from the other.
You could separate out the one from the other. So what happens? Well, firstly, Leveson makes one very short and I think powerful point.
Well, let's just cease to be subjective, shall we? Let's look at Mr. Foster's statement.
There is what I think of as a moment of terror, and there's certainly silence and what looks like a little panic. And it's only at that moment, I think, that Mr. Brett realises what's about to happen. Let's just cease to be subjective, shall we? The time when his zeal is tested.
So, to put the context of the statement in, he's talking about the blog, and he says that he decided that one or two things had to be true, and that it was in public interest to reveal it. So there he is, wanting to find out who is responsible for Nightjack. And then he talks about paragraph 9, which Mr. Chair's asked you about. And then he goes on, quote, only 24 hours to crack the case, which is a citation from the blog. Would you agree that the inference from this statement is that this is how he went about doing it?
Yes, it certainly does. Yes.
And then he starts at paragraph 12. I began to systematically run the details of the articles in the series through Factiva, a database of newspaper articles collated from around the country. I could not find any real-life examples of the events featured in part 1 of the series. And that suggests that that's where he started and that's how he's gone about it, doesn't it?
It certainly suggests he has done precisely that, yes.
And that's how he's gone about it.
Yes.
That's not accurate, is it?
It is not entirely accurate, ma'am.
Paragraph 15. Sorry, Mr. Chair, I've started now. Paragraph 15. Because of the startling similarities between the blog post and the case detailed in the newspaper report, I began to work under the assumption that if the author was claimed as detective, they probably worked, etc. Same question. That simply isn't accurate, is it?
My Lord, we're being fantastically precise.
Oh, I am being precise because this is a statement being submitted to a court, Mr. Brett.
Yes.
Would you not want me to be precise?
No, of course I want you to be precise. It's not the full story.
Paragraph 20. I repeat, I'm not enjoying this. At this stage, I felt sure that the blog was written by a real police officer. That is utterly misleading, isn't it?
It certainly doesn't give the full story.
Well, there are 2 or 3 other examples, but I've had enough.
Brett's final throw of the dice is to suggest Leveson's fantastic precision is unfairly skewering him. It is, I think, both desperate and hypocritical. He had sought to gain precision zealously when he said the hacking claim was baseless, and in his attempt to compartmentalise Horton's identification when drafting that Horton had begun by conducting a legitimate search, he did not cease to be subjective, he magnified subjectivity. What lessons do I suggest this illustrates? Zeal, the facility to make an argument on the slenderest of bases, coupled with the ability to ignore convenient facts because they will never be disclosed, because they are privileged, is dangerous. It poses explicit dangers to honesty and integrity. As the High Court said in dismissing Mr. Brett's appeal against disciplinary prosecution, the evidence pointed inevitably to the conclusion he had allowed the court to be misled. But there may also be more at work here, because my third point is that our psychological frailties might magnify zeal, or zeal might magnify our psychological frailties. There is a fascinating literature on behavioural ethics and the psychology of lawyers. The central point of this literature is that many ethical infractions result from a combination of situational pressures and all too human modes of thinking. Now, I can't discuss all the possibilities tonight, but I want to suggest that these all too human modes of thinking, frailties for short, can amplify the adversarial habits of a zealous lawyer. As lawyers, we are demonstrably and likely unwittingly prone to assess cases as stronger just because those cases are taken for clients rather than others. This team loyalty bias renders our judgments weaker. Furthermore, if our client is a hallowed institution, or we can portray our opponents as disloyal or thieves and liars, this moral intensification makes us less ethical. Pragmatism makes us impulsive and less principled. We can descend down slippery slopes via strategies which are reasonable when unchallenged in the abstract in our heads, like Alistair Brett's legitimate identification, but become deeply problematic in their execution. We're also prone to the agency effect. We are more inclined to do certain unethical acts for others than we are for ourselves because of the moral fillip of helping others. We compensate up to a point in our calculations for morally questionable acts on their behalf. Competitiveness, thinking like a lawyer, overload, all can dull our sensitivity to moral problems. Zeal and human frailties can form a heady cocktail, pushing arguments and evidence then beyond honesty and integrity. That brings me to point 4, zeal and cultural identity. Lord Brougham, a famous lawyer from days gone by, after his defence of Queen Caroline against the then King in Parliament, famously celebrated zeal. Clients should be served, he said, by all means and expedients. Lawyers should disregard the alarm, the torments, the destruction which he may bring upon others. He must go on reckless of the consequences, reckless even to his own interests. Brougham's words are emblematic of fearlessness, arguably the one word in the bar's code of conduct that strikes an emotional register. Technically unnecessary, fearlessness remains there, I would say, for aesthetic impact. It remains to promote a feeling that zeal is selfless and heroic. It may make zeal the most psychologically appealing idea about what it means to be a lawyer, and I think it lionizes harm. Now, Brougham, interestingly, repudiated his words in later life, but empirical work on lawyers has tended to suggest that they too think that client first was bred into them, even though the rules say different. And there's evidence that zeal might be underlaid with self-regard rather than pure selflessness. And of course, it rather goes without saying that, at least when paid on an hourly basis, zeal and lawyers' economic interests may be heavily aligned. Now, I'm not suggesting zeal is never merited. Lawyers sometimes need to resist pressure to ignore proper arguments or compromise their clients' cases unfairly, and a more robust defence of sub-postmasters when they were prosecuted all those years ago might sometimes have tempered the extent of the disaster. Unusual effort and courage were both likely necessary for the victories in the Bates and Hamilton cases. So in one sense, the problem is a simple one. Zeal and our human frailties push restraints to the back of our mind when they should be closer to the front. Ethical thought and practice needs to reflect these psychological, sociological and economic realities, the realities that already push well-resourced lawyers towards zeal when cases like Brett suggest they need to pull back. Now, I would tend to go further than the professional codes, which already make zeal subordinate to the interests of justice, and I would reframe the issue as one of proper rather than zealous representation, and dial back its aesthetic register because it can unbalance lawyers when they most need balance. But I would also challenge or qualify some of zeal's sister concepts. Now, Lubin, American lawyer philosopher, calls zeal's sister concepts adversary system excuses. The ideology of the legal system is, of course, adversarial. It is a party's right, a mark of the rule of law, to be allowed and for lawyers perhaps to be required to take any properly arguable point. Now, properly arguable is a pretty low bar, but also lawyers are not the judges of their clients and sometimes claim not to have to investigate the truth of their client's case. Now, these are sort of half right or part truths which close the mind to complexities in the situation. Brett didn't just not judge his client, he created him a new truth. Nor does not judging your client mean never doing due diligence on what they say, and bringing every single arguable point creates an untenable mismatch between zeal and, in civil cases at least, proportionality. A particularly interesting sister concept is a claim made about morality. Lawyers often say they do not do morality. We advise on law, not morality. We are not morally accountable for our clients' actions. Now, the argument can be disingenuous. If you assist a client in an immoral act, its legality does not necessarily mean you are not morally accountable. And SRA guidance suggests you may sometimes be professionally accountable. Lionizing amorality can also be a way of doing morality whilst pretending not to. Rob Atkinson has argued the standard conception embraces sophistry in the service of a distinctly diminished form of political justice. His point is, I think, a lawyer's claim neutrality is not amorality, it is one-sided, one-eyed morality. Neutrality and the operation of zeal, in other words, are heavily skewed by inequality of arms towards the morality of those with power and resources. All the standard conception does is put a moral veneer on the legal services market. It mutes the moralities of those with limited resources. They have their cases filtered through merits and means tests, their tactics limited by funders, their seeking of justice curtailed by the costs of losing. If you look at the hacking cases and the people there forced to settle their claims, you can see how law's one-sided zeal operates to protect, if you like, the people who have probably done wrong there. And we've started to see that in the Prince Harry case, where lawyers have been, I'm sorry to say, quite heavily involved. The bar's cab rank rule, whether you support it or not, aligns with this commercial and reputational interest of the bar better than with access to justice. Suggesting one represents oil and gas clients or Russian oligarchs because of a belief in the rule of law is the figgiest of fig leaves. The alignment of practice with money, though, goes well beyond confining zeal to the well-resourced. Judging firm and fee earner reputations on fee earnings has long been linked with the erosion of professionalism. League tables measure eliteness on profit per equity partner, and that signal cascades down. Commercial firms squeeze out morality that might offend clients in other ways. Some US firms drive out volunteering for progressive causes, even from their lawyers' private lives. Rob Atkinson's argument means only a select few get to really make arguments, really claim rights, manage facts and assert their own moral claims. The others are more often subjected to them. In this way, the powerful get to take advantage of a phony neutrality in ways that can be abused. The courts struggle to handle such sophistry, such advantage taking. Take as an example the Mercy case. Mr. Mercy brought a libel action against ex-Conservative MP and activist Charlotte Leslie. It was said to be abusive and a slap. Mr. Mercy said, "Nothing could be further from the truth. The right to bring a legal claim is a fundamental right in a democracy, and it is my wish, as well as within my right, to challenge the defamatory allegations that have been made about me by the defendants in a court of law in order to vindicate my reputation." Mr. Mercy's claim failed because his lawyers did not plead serious harm to reputation. The judge declined to consider whether it was abuse, though, instead listing all the behaviour in tension with a solid case for legitimate vindication. He said there was an exorbitant approach to litigation. Complexity was increased without tangible benefit. It was wholly disproportionate and can't have had regard to the overriding objective. There had been a deliberate and tactical use of multiple proceedings, and there was collateral evidence of the desire to embarrass the Conservative Party, which was not a legitimate purpose of the litigation. Now, judges often avoid issues of abuse or propriety, preferring to decide cases on their main grounds. Issues of abuse and impropriety slow them down, are likely to be hard fought, involve the drawing of high stakes or distasteful inferences. Calling someone a liar, for instance, requires particular care and may increase the likelihood of appeals. So you can see why discretion may sometimes be better than valour, but it can also signal a tolerance of poor conduct. Such caution is one reason why the courts alone cannot protect the rule of law from abuse. Powerful actors also have many ways of avoiding the scrutiny of the courts, including settling cases, and most slaplight problems, for instance, take place away from courts. So this emphasises the importance of lawyers' ethics and their guardians. I want to move towards a conclusion this evening by holding in mind Atkinson's idea then of hypocritical lopsided morality and Broom's fearless disregard for harm to others. And the first point to make is a moment to let emotion fill this room. I make no apology for this emotion. I will develop the point in the third lecture, but morality should inform our judgments whilst not dictating them. We should think of those sacked and slandered, imprisoned, aged 19, after refusing to apologise to the judge 22 years ago, kept out of jail by her friends in the village having a whip round for her enormous debts, imprisoned in his 50s, a pillar of the community sent to Walton Jail near Liverpool, jailed when 10 weeks pregnant. The shadow cast on their lives and the lives of their families is beyond extraordinary. Lawyers distancing themselves from harm may be part of the reason they make the mistakes they do. An ethic of fearlessness encourages lawyers to see the costs of these people as simply the price of doing business. It is moral anomie, a logic that renders them hired guns with scripts that become semi-automatic weapons. I have to take this client. My client has given me these instructions. I must follow my instructions. I can disregard any harm and not judge my client. These scripted simplifications switch off moral sensitivities. Whether disregarding harm is theoretically justified or not, my view is it's not, but the law suggests otherwise sometimes, the dangers of it should be plain. Zeal discourages reflection. It makes us more likely to miss the time when our client does not have a right to make a claim, or our actions are an abuse, or the taking of unfair advantage, or our zealous interpretations look rather like, or become like, lies. Sometimes they are lies. Loyalty is an important part of any professional relationship, and the proper protection of legality, of which rights are a part, is important too. But lawyers can trip themselves up with adversarial logics and their own self-concept. As Lord Hoffman has emphasised, lawyers owe divided loyalties. As Lord Thomas said, advocates are responsible for strategy on a case, not the client. As Lord Justice Jackson said, lawyers must take particular care not to mislead. They must be scrupulously honest. As Baroness Hale has noted, privilege, secrecy is given to enable lawyers to give advice, sensible as to conduct. The rule of law demands lawyers attend to the proper values of the system. The problem is not usually or only cleverness and arrogance. It can be opportunism or desperation, grasping for the one point that lets us help our client and allows us to seem in charge of events. We can resist disclosure that way. We can be fantastically precise. Ethics begins in the half-light of these hasty decisions. Most lawyers do not think they are gods, of course not, but the logic of partial facts and available argument is a logic of expedience and sometimes extremism. Next week I'll be explaining how it drives cover-ups. We need to think radically about how to dial down zeal and consign self-regarding fearlessness to the history books. If the profession is really to promote justice or the rule of law, it needs to change the way it thinks and behaves. Because we know now how expedience ends. It ends with this remarkable list of problems and these quite extraordinary people. They have not been let down once. They have been let down many times, harmed by an army of lawyers still desperately trying to avoid responsibility. Often, not always, but often those lawyers were in the wrong. Some were negligent, some reckless, some lacking in integrity, some, I am incredibly sorry to say, probably criminal. Some do not even have an arguable excuse. And as all good lawyers know, not having an arguable excuse, well, that's a pretty low bar. Thank you for listening.